ఇంకెన్ని రోజులు జరుగుతుంది?
Number 1, Lokesh K.
Here for the appellant. The appellant agreed by the order passed by the Honorable Single Judge dated 7/3/2022 filed this writ appeal. Lord, the facts of the case, Lord, the subject matter of the petitioner, the appellant is claiming the right over the ancestral properties. Lord, the revenue entries has been mutated without considering the name of all the other joint family members. Lord, Nanjundappa was the one proprietor of the family, Lord, and he has 3 sons, Lord, and only the one son name, Lord, one son legal heirs name, only revenue entries has been transferred by the Tahsildar. Same was challenged before the Assistant Commissioner. The Assistant Commissioner, Lord, has allowed the appellant jointly continue the revenue records in the name of the petitioners as well appellants as well as the respondent, and also filed. We also filed regarding revenue entries. Millard is concerned. Millard, I have produced the revenue records, page number 110. 100. Your worship may kindly see the mode of acquisition of property in column number 10 of the RTC. Millard, it is very clearly indicates that
you were the petitioner.
Yes, Millard, I am the petitioner before the single judge.
My lord, is filed a suit a partition. We were 2010, my lordship.
Correct.
And suit is pending, and wherein he sought for partition as what of the cancelled the sale deeds. And after lapse of 17 years, 7 years, my lord, he put an application for the Assistant Commissioner. Assistant Commissioner passed an order changing the nature, the mutation which is affecting my name, because the property belongs to the partition. And he directed the concerned authority to mutate the property in the name of the applicant sharing. I have challenged that order, my lord. The deputy commissioner reverted the order. Against that order, my lord, the prepared an writ petition, dismissed, my lord. And it is pending in respect to entire property is concerned.
Sorry, Mr. Nothing. Your partition suit is pending.
Partition suit between the two family members.
Is pending. Now, where is the question of mutation in between when the partition has not yet finalized?
Milord, regarding mutation is concerned, Milord, the
You
revenue
lost
records.
in the revision, you lost in the writ petition. Now you are in the appeal.
Milord,
What
kindly
is
just
the
look at,
ground?
Milord, a provision, Milord, section 128 of the Karnataka Land Revenue Act. I may be permitted to read
Yes.
only single two sentences in the 128, Milord.
Yes.
Milord, acquisition of right to be reported. Any person acquiring by a succession, survivorship, inheritance, partition, purchased, mortgage, gift, lease, etc. Any right holder, occupant, the revenue entries has to be affected. Milord, here the inheritance kata was named in the name of the respondent number 4. Inheritance kata. Inheritance
Wait,
kata
wait.
is also covered
Wait for
128.
the disposal of a partition suit.
Milord, partition suit is there. The Tahsildar has a no jurisdiction to mutate only in the name of one person. We are 4 family members, we are 4 children. Only single person name mutation was inheritance kata
All
made.
these issues have been dealt with in the full bench. By the full bench,
Milord, full bench court judgment Jayamma versus State of Karnataka, where Milord, title regarding properties and revenue entries is always subject to result of civil suit.
right.
Here, Milord, my submission.
you,
Milord.
you filed a suit for partition.
Absolutely, Milord.
During the pendency of the suit, you asked for mutation of kata. The assistant commissioner has changed it. Deputy commissioner says till the suit is decided, question of changing the kata does not arise. Correctly so. Learned single judge also had said that revenue entries would follow the result of the civil suit.
Milord, the assistant commissioner say, held, Milord, the revenue entries has to be affected jointly in the name of inheritance kata
Assistant-
cannot be made in the name of one family member.
As on the date the assistant commissioner passed an order, there was already a civil suit pending.
Absolutely.
Therefore, he should not have directed any change in the revenue records till disposal of the suit.
But the assistant commissioner held, Milord, these revenue entries to be
That's what-
continued in the
that's
name
what-
of joint family and subject to result of original suit
So,
pending before the civil competent civil court.
The assistant commissioner, the moment it is brought to his notice and having referred to the civil suit,
Yes, Milord.
should not have tinkered around with the revenue records. That has been correctly reversed by the deputy commissioner and
The question of regarding entries 129 of the Karnataka Land Revenue Act, whether the acquisition mode of the acquisition is
want
by
us
way of
the
ancestral.
problem is you want us to go into your inter se rights.
Yes,
It may affect your rights in the civil suit. All that the learned single judge, deputy commissioner and assistant commissioner have said is subject to outcome. So leave it at that. We'll clarify that the revenue records would not affect the rights of parties in the pending civil suit.
then
Right.
Otherwise also it does not confer any.
independently, Milord, we have to do whether we are the joint
Even if
family
we don't
members or
clarify
the.
also, that is the
Milord,
legal
what happened
position.
taking
The
advantage
revenue
of this
authority
revenue
does not
entries?
confer the title.
Absolutely, Milord, taking advantage of these revenue entries.
Right?
when the ancestral-
It never confers any title.
But he cannot claim independent right based on these revenue entries because it is ancestral property. Revenue record discloses way back in 1970s itself, it is ancestral property.
You will accept notice for other respondents, no, only R4.
Won't happen, my lord, because other parties are the formal parties, my lord. I am the contesting party. My lord.
Learned AGA accepts notice for respondents 1 to 3. Full stop. Learned counsel for the KVNR respondent number 4 accepts notice for respondent number 4. For the order proposed, notice to the remaining respondents is dispensed with. Full stop. Heard learned counsel for the petitioner and learned counsel, learned AGA for the respondents 1 to 3 and the learned counsel for respondent number 4 and peruse the material on record, including the impugned order. Appellant and peruse the material on record, including the impugned order. That's right. That's right. The material on record discloses that there is a civil suit in OS number 616 of 2010 between the appellant and the respondents and the private respondents, which is pending on the file of the first additional Senior Civil Judge, Bangalore Rural District, Bangalore, in respect of the subject properties in relation to which the subject matter of the present appeal arises with regard to as regards the revenue records. Full stop. Full stop. A perusal of the impugned orders passed by the Deputy Commissioner as well as the learned single judge will clearly indicate that the revenue records standing in the name of the respondent number 4 have been directed to be subject to the outcome of the pending civil suit. Full stop. Under these circumstances, comma, by clarifying that no right would flow in favor appeal without interfering with the impugned order passed by the learned single judge. That's it. As held in the full bench Jayama's case.
I don't,
No,
there's no
that's
need
better.
to, because that is on different issue. Leave that.
Number 2. Yeah.
For the private army.
Please, my lords, in this matter.
I submit that a copy of the appeal may be served on.
We have, sir.
Yes.
Please, my lords. This is the appeal of the defendant challenging the judgment passed by the trial court, my lords, allowing the suit filed by the plaintiff, my lords, granting a sum of rupees 81,85,530 rupees as the principal and interest due payable to the plaintiff, please, my lords. My lords, the whole contention before the trial court, my lords, of the plaintiff is that they were the ex-directors, the plaintiff was the ex-director of the company. He had given certain deposits, and after 5 years of the settlement that is taking place between the parties, my lords, they are asking, the plaintiff has sought for the refund of that investment. A due settlement has taken place between the parties, my lords. I will take your lordships in the paper book that is filed at internal page 8. The contention that is taken before the trial court in the suit is that, my lords, I may be permitted to read the depositing of money made by the plaintiff in the defendant company.
Where are you reading?
Lords, the additional paper book which I filed, page 8, internal page 8, in page 8 of the paper book which I filed, please.
I may submit, even a copy of the appeal has not been furnished to us.
We did file, serve, Lords.
50%. Last appeal.
कुछ additional paper दिखा रहे हैं.
Action के लिए 50% deposit करने से last appeal. So we have
You some settlement has been arrived. No, he's saying that some settlement has arrived. The parties are subsequently.
No, during the pendency of the suit, sorry, prior to the suit, plaintiff says some settlement he agreed to pay, but defendant's defense's signatures were taken on blank papers. So that
My lords, on the principal amount, 50% may be avoided.
on the dignital amount,
Well,
if you want to stay, or if you don't stay, then we'll admit it.
Of course, I'm not on that place, my lords. Interest amount that is claimed itself is around 37 lakhs. Principal itself is 46 lakhs.
We are not concerned about what has been the amount in the interest. Whatever is the decretal amount, interest up to date of that, you have to pay the 50%. If you are ready, then we will stay the judgment and ask them to find the response.
I may be given 4 weeks time to deposit. My
Third, learned counsel for the appellant and learned counsel for the respondent, and peruse the material on record, including the impugned judgment and decree passed by the commercial court. Full stop. In addition to reiterating the various contentions urged in the appeal and referring to the material on record, learned counsel for the appellant submits that the specific defense put forth by the appellant defendant, that his signatures were taken on blank papers, has not been correctly and properly appreciated by the commercial court. Is that the defense?
MOU.
MOU.
The settlement that is taken,
Settlement.
not a blank document, it's the MOU that is.
That is the defense.
I have.
All right. The various defenses urged by the appellant defendant before the commercial court have not been correctly and properly appreciated by the commercial court, and this has resulted in erroneous conclusion. Full stop. Said submission of learned counsel for the appellant is placed on record. Matter requires consideration. Appeal is admitted on IA number 1 of 22 for stay. The operation and implementation of the impugned judgment and decree passed by the commercial court is hereby stayed, subject to the appellant depositing 50% of the decretal amount with up-to-date interest as on today within a period of 4 weeks from today. Full stop.
That amount may be kept in the FD bearing, interest bearing FD.
Immediately upon deposit, the registry is directed to invest the same in a fixed deposit for an initial period of 1 year and subject to periodic renewal till disposal of the appeal. Full stop.
Lodge, if I may submit, Lodge, there is nothing left in the company except one linear and accelerator machine, which is around 3 crores. Maybe directed not to alienate that machine.
No, Miller, I am.
You can't do that.
Reason is,
I'm
I'll file an
depositing-
application. I'll file an.
Can you put the appellant on terms? We can, I think.
We can say that.
It is further directed that
Not alienate.
the appellant shall not alienate.
Alienation and also deposit, Millard. I am a hospital.
You want to sell.
I'm not selling it, Millard. I'm
You want to
using
sell
it
the
in-
machine and deposit.
No. I'm not selling the machine and depositing, Millard. There are two orders on the same party.
But you will not alienate the property.
Millard,
alienate the
alienation doesn't happen, but it's a 10 years old machine now. Millard.
Whatever it is.
It's a 10 year old machine. It requires certain repair. I was.
All that. Details of the machine because we don't have it here.
Yes, I will file.
We don't have the complete
In fact, it is
details.
brought out in the, I'll file an application.
Please,
Much.
Number 3.
Hearing for the appellant is the defendant appellant appeal arising out of judgment passed by the commercial court. Millard, it is the land relationship between the parties. Millard is the landlord and tenant. The defendant appellant is the landlord. Respondent plaintiff is the tenant. Millard, between the parties, Millard, there was a registered lease agreement between the parties on 9/7/2012. Millard, lease was 5 years. It was a lock-in period. In between that, Millard, the tenant want to vacate and evict, and he want to hand over the possession. He has to give a prior notice of 2 months advance, 60 days notice. It is a registered agreement. Millard, without issuing notice, Millard, he has not. He vacated property and handed over the keys in the open court by filing a suit and issuing a termination of tenancy, the lease agreement notice. Millard, it is
For mediation. You take out notice, that is matter for settlement. Matter to be settled.
execution filed, Millard. Therefore, Millard,
We will stay everything provided they agree for mediation. The respondent, let the respondent appear, and what we feel that the dispute between the parties can be amicably settled through mediation. So if both the parties will agree, then for that period of mediation, we will stay the.
in the meantime, what happened, Millard, execution court is posted on 12/4 for further
Give
proceedings.
a date, give a hand notice, take a hand notice. And
Yes.
we'll-
Yes,
After hearing the learned counsel for the appellant, come aware of the view that there exists an element of
We
positive.
don't say.
Don't say all that. All right.
To give hand
Right.
notice only.
Right. Issue emergent notice to the respondent returnable by April 1st week on date.
12th is our in execution proceedings.
Give a date.
7th April,
7th
No,
April,
Early date, early.
early,
4th April.
4th April.
Right.
Appellant also permitted to take out hand
And
summons
to trial court appearing in
to the respondent, company.
learned counsel appearing as well as to the learned counsel appearing in the trial.
As well as
court.
learned counsel appearing for the respondent before in the suit before the trial court.
Number 4.
Didn't respond it. My lord. I'm extremely sorry, my lord. On the previous
Number
day,
10 advocate
not-
and as well as the president of the association.
my lord,
Just a
extremely
minute,
sorry, my lord. On the
Just-
previous day,
just
because-
a minute, wait. Yes,
my lord, I'm extremely sorry, my lord. Because on previous day, because of the communication gap, my lord, I could not able to attend the court, my lord. Then the complaints were filed, my lord, sorry. The 9th respondent, they found a solution to provide land to the 10th respondent, my lord, to erect the proper place.
why he did not appear? No, why he did not appear?
Here,
Because of some communication, my lord.
Huh?
Some communication gap.
communication.
Gap.
What communication gap?
Because I not received the message, my lord, that is why.
Which message you want to receive before appearing?
The previous sarcasm, my lord.
Huh?
A previous sarcasm, my lord.
What message?
The telegram message, my lord. Telegram message, my lord.
High Court caused
High Court telegram process.
Telegram is software was developed by the High Court. He could not receive the message for listing of the case, was what he intended to tell me. Past list-
That is the only,
You are practitioner of this court or not?
my lord, I'm practicing, my lord.
Then-
But on that day, by mistake.
Then we will remove your name from the roll of advocates.
I received other cases, my lord, but this court not missing, my lord. I received, my lord, other court's message, but this court message is not.
Don't blame the court. Don't blame the High Court.
Sorry,
You
extremely
are
sorry, my lord.
responsible for that.
Sorry, my lord, extremely sorry, my lord. For that, I'm sorry, my lord.
Whether every advocate is required to be given a notice every time when the case is listed,
Sorry, my lord.
or it is your responsibility to find out.
Please, my lord.
Then what is all this?
I'm extremely sorry, my lord. Please, my lord.
Petitioner was disposed of based on his undertaking. Writ petition was disposed, this petition is disposed of based on his undertaking that halfly installed statue of Dr. Baba Saheb Ambedkar, he would shift that. He has to say on that, when he will shift and all. That is only left out. Only compliance is left.
That is the reason he was not appearing. That is why we called his appearance. We understand.
Yes. Yes.
Now he is telling that he did not get notice. Yes, what is to be done with you?
Extremely sorry, my lord.
Why contempt proceeding should not be initiated against you? You gave the undertaking to remove the statue.
But I filed affidavit, my lord. I got affidavit, my lord. On 1st February, I filed the affidavit, my lord. Compliance affidavit. After that, my lord, the Gram Panchayat has given the land to me, my lord, to shift the land, the statue of the Dr. Ambedkar.
We don't want any explanation. We want compliance.
I already filed my compliance affidavit, my lord, on
Yes.
1st February 2022.
Sir, have you shifted or not?
No, my lord.
Yet to be shifted, my lord, it
When
is.
will you shift?
And
week?
remember,
1 week?
Then let the proceeding be initiated against you.
at least on the
You
10 days,
are,
that is.
you are taking the court very lightly.
Extreme, my lord.
No.
15 days, that is not.
You will understand, mister, you are a lawyer, but you don't understand the meaning of the court order. We'll make you understand. We'll make you understand what is the meaning of the court order and what happens if you don't comply.
10 days, my lord, extension, because it takes some.
What is all this? You gave the undertaking. Why you have not complied?
Because, my lord, the government did not come forward, my lord. The government DC not come forward to provide the land, my lord. Because, my lord, the Gram Panchayat given land, my lord. That is the mistake, my lord.
That may not be
Previous
correct.
occasion
We have in the beginning only we have made it stand clear that we will not be able to provide my lords any land to such my lords. Illegal erection of the statue. my lords.
1 week.
We'll give you 1 week time to comply.
Go ahead, my lords, please.
And if the statue is not shifted as per the court's order, as you had given the undertaking,
Please,
then you will have it.
please, my lords.
Yes.
Yes.
Last opportunity. Can you get away after giving an undertaking?
My lord, it is,
Now you are giving the excuses.
9th August, my lord, 20, my lord.
By final order dated 13/8/2021, this court disposed of the present petition, issuing the following directions. Page 11, para 11 and 12. Page 11 and 12, para 11 of the order. Full stop. Pursuant thereto, the respondent number 10, represented by respondent number 9.
No, 10, my lord.
Respondent number 10, represented by its president, has filed a compliance affidavit dated 1/2/2022. Full stop. When the matter was listed on 17/3/2022,
Undertaking is not to be giving undertaking.
affidavit of undertaking, respondent number 10 specifically undertook to shift the statute of Dr. Baba Saheb Ambedkar from the as directed by this court. Full stop.
That undertook by him.
As directed by this court. Full stop. Subsequently, when the matter was listed on 17/3/2022,
Within a period of 4 months.
within a
It would require period of 4 months in order.
months from 9/8/2021. Full stop. Subsequently, the matter was posted on 11/1/2022, on which date no compliance affidavit was filed by the respondent number 10. Full stop. Subsequently, on 2/2/2022, an affidavit was filed
1/2, my lord.
1/2/2022. Right. Right. In view of the continuous non-appearance, we will extract this also. Full stop. In view of the fact that the respondent number 10 did not appear nor comply with the undertaking given by him, this court passed the following order on 20/12/2021. Please extract. So, on the next date of hearing, in view of the retirement of the learned counsel for the respondent number 10, this court by order dated 11/1/22 directed the registry to print the name of respondent number 10 in the cause list and listed the matter on 1/2/2022. Full stop. On that day also, the matter was once again adjourned to 22/2/2022. Full stop. Meanwhile, the respondent number 10 has filed an affidavit of one Revan Siddhappa, the president of the respondent number 10 association. Respondent number 10 association undertaking to
Not undertook anything. It is not undertook. Nothing is stated, my lords, here in the affidavit.
affidavit of compliance. 1/2/2022 is after that day. Filed one more affidavit of compliance. Full stop. And the matter stood adjourned to 17/3/2022. Full stop. On 17/3/2022, this court noted that noted the said affidavit as well as the fact that neither the deponent who had sworn to the affidavit nor the learned counsel for the respondent number 10 were present and adjourned the matter to this day. Full stop. Today, learned counsel for the respondent number 10 submitted.
No, he is present or not?
And posted the matter to this day by passing the following order. Please extract 17/3/2022 order. Next one. Full stop.
Whether Ravana Siddhampa is present
He's
today?
present, is it?
Milord, he present my lord, but in the outside court, my lord. He present in the court, my lord. The present my outside, my lord.
Why?
But not, but in judgment present in the court, my lord.
Where is he?
Then he is outside, my lord. He is outside the court, my lord.
Why he is outside the court? Case is here, he is to appear. His appearance is fixed.
Can you pass over the matter, my lord, because the party is there.
No, we will ask for police to arrest him and bring him here. He will be arrested and brought here. What is this? You are playing tricks with the court?
Outside, my lord, outside the court, my lord.
Where is he?
Outside the court, my lord. I will get my lord. I will get that permission.
After so much of efforts, now you have come, but he is still not present before the court.
But that is,
He is the person.
he is the person, my lord.
Call him here.
The 10th respondent.
Call him here. Come here. टाइट करो थोड़ा नहीं तो
affidavit file ಮಾಡಿದಿರಲ್ಲ ಒಂದು ವಾರ ಒಳಗಡೆ ಶಿಫ್ಟ್ ಆಗಬೇಕು. You can understand English? Can you understand English? Can you understand English?
Understand, my lord. Understand.
Yes or no? 1 week time. No, 1 week we are granting. If you don't shift within 1 week, we'll take action against you. Your counsel has agreed for 1 week. 1 week from today. Sir, 1 week we are granting. Last time you did not come. Previous time also you did not come. Your name was printed. Your previous counsel retired from the case. You have continuously noted your absence. In August 2021, you wanted 4 months' time. 4 months' time got expired. Again, we sent for you. Then you came. Then you engaged a new counsel. Last time you did not come. This order
when the summons were issued to you by through CGM, now then you are
finally
appearing.
you had to come. You can't grant in 1 day more than 1 week's time. Either you shift within 1 week or we'll have to take action against. Sir, one thing, 1 ವಾರ ಕೊಡ್ತೀವಿ ಇವ್ರೆ, 1 ವಾರದೊಳಗಡೆ ಶಿಫ್ಟ್ ಮಾಡಿ. 1 month ಕೂಡ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ತಿರ್ಗಾ ಕೇಳ್ಬಿಡಿ, ಪ್ಲೀಸ್ ಡೋಂಟ್ ಆಸ್ಕ್ ಅಗೇನ್. ತಿರ್ಗಾ ಕೇಳಕ್ ಹೋಗ್ಬಿಡಿ. 1 week ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
One week.
1 week.
Note his appearance is undertaking.
Pass the following order. Today, ಇಲ್ಲ ಇವ್ರೆ 1 week. ಸ್ಟ್ಯಾಚ್ಯೂ ಶಿಫ್ಟ್ ಮಾಡಕ್ ಎಷ್ಟೊತ್ರಿ? ಎಷ್ಟೊತ್ತು ಬೇಕು ಸ್ಟ್ಯಾಚ್ಯೂ ಶಿಫ್ಟ್ ಮಾಡಕ್ಕೆ? ಈ ಮ್ಯಾಟ್ರ್ ಪೆಂಡಿಂಗೇ ಇಲ್ಲ, ಡಿಸ್ಪೋಸ್ ಆಗೋಗಿತ್ತು. ಸಾಕಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ ಇದು ಆರ್ಡರ್ ಆಗ್ತಾ ಇರೋದು, ಯಾವತ್ತೂ ಆಗೋಗಿತ್ತು ಆರ್ಡರ್. ತಿರ್ಗಾ ಕೇಳಿದ್ರೆ ತಪ್ಪಾಗುತ್ತೆ. ನೀವು ಕೇಳೋದು ತಪ್ಪು, ನಾವು ಕೊಟ್ಟರು ತಪ್ಪಾಗುತ್ತೆ. ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಟುಡೇ the aforesaid Revana Siddhappa, SP, along with the learned counsel for respondent number 10, are physically present before this court. Full stop. Both the aforesaid Revana Siddhappa on behalf of the respondent number 10 association, as well as the learned counsel for respondent number 10, submit that they would ensure that the aforesaid statue is positively shifted from its place, from the place as directed, from the place it stands now as directed by this court in the final order dated so and so, with on or before today's date 24 on or before 1st April 2022. Full stop. One more affidavit today, not required. Not required. Full stop. The submission of Mr. Revan Siddhappa as well as learned counsel for the respondent number 10 is placed on record, released on 4/10/2022 to report 4/4/2022 to report compliance.
Take a week's time not to go ahead with the matter. Last occasion, the Lordship said directed the parties to prepare.
Formal order on the application. Pass,
Application has been filed.
Yes, Mr. For withdrawal of 3 crores amount.
Where is the NK Ramesh?
I'm given to understand, yesterday I did personally talk to Mr. NK Ramesh. He has informed me that necessary proceeding, the application before the registrar or some receipts, etc., it was not signed and placed before the registrar. They may take another 3-4 days. That they have got some technical difficulties. That's what Mr. Ramesh has informed me. That is regarding the withdrawal of that amount is concerned. So far as the merits are concerned, my petitioner's counsel seeks a short time. It is a my lord's can.
Week's time, my lord, prepare for the matter.
That's right. Oh, correct. We'll have to fix it next week.
Will adjourn today.
Please,
We shall add.
please.
After a week.
1 week.
1 week after. Meantime, my lord's formal
My lord's only
objections we also not filed. I have completed, my lords. It's ready. I am filing today in the counter. Next week, my lords.
What do you have to file?
Final, my lords, interim orders, we have filed a compliance reports, many payments are made, but formal objections to the read petition, my lords, it is ready, my lords. Today I am filing in the counter. First, kindly have it next week.
AGF was allowed a week's time to file the statement of objection. You appear for respondent number?
Lords, respond number 1. Statement. 1. Number 1. Next week in it.
Give a date. After 1 week, 10 days. Give any date. Note the appearance of the Additional Solicitor General and the Counsel for the Central Government.
Please.
Let to modify. Second, third, let 1 or 2 here.
First is 1st April. All right. Give me-
Withdrawal.
Not survival.
Withdrawal
The order
is
we have withdrawn.
not withdrawal.
Filing a memo. Today only I got. Impugned order itself not we have withdrawn. A subsequent order.
Annexure A, regards this order.
Withdrawn, no?
We withdrawn it.
There are office objection. There were office objections, my lord. In reply to that office objection, he submitted that it may be posted before court as we are withdrawing the.
Annexure A, providing the benefit to these two communities, this order is withdrawn.
We have withdrawn. Just permit, I'll file. Just now I got the copy.
Close it. So,
Then
then
it's saying,
AGA has-
we'll record both and
Commissioner has filed a memo seeking withdrawal of the petition. Full stop. So also learned AGA has filed a memo.
Along with the government order. Along with government order dated
Government order dated
15/3/2020. 3/2022.
15/3/2022, whereby
We have
the
withdrawn.
impugned order at Annexure A dated 16/1/21
Yes.
has been withdrawn by the state government. Both the memos and documents are placed on record. Petition stands disposed of accordingly. Dismissed as withdrawn.
Memo of the petition.
Okay. Counsel submit. Learned counsel for the petitioner submits.
instead of memo, just.
Sub-
Plaintiff's appeal. The suit is returned to me, saying that the court has no territorial jurisdiction. My respectful submission is the notifications issued by the state government clearly depict that there is a concurrent jurisdiction conferred on two courts. That is the limited point. Rest of it, once the suit is restored, I can argue before the court on merits. Now the limited point.
That notification.
Please, Lordships will get that notification at page 193. It is in Kannada, the translation copy is annexed in page number 196. Initially, Lordships will see 196. Initially, three commercial courts came to be established. Page 197. Page 197. Three commercial courts came to be established. One is additional city civil and sessions court in Bengaluru, which had jurisdiction over Bangalore urban district, Bangalore rural district. Then additional city civil and sessions court Bengaluru, Chamarajnagara and other districts that are enlisted there. Then Ballari court, it had jurisdiction over all these courts, Bagal court, Belgaum, etc., etc. Then this was the situation prevailing as on the date of this notification of 31/7/2018. Subsequently, Lordships will see page 202, which is the true translation copy of the annexure, notification of 9/10/2019. Now, what the government did, instead of conferring jurisdiction on these courts, every district they established commercial.
It's not about that. It's about whether the Ramanagara court or the Hyderabad court.
No. Hyderabad is not there.
That's a contention.
No, the issue is, Ramanagara court, they say there is jurisdiction.
Where is the finding with regard to jurisdiction?
Yes, Lordships will see page 43. Para 15 on. In fact, it starts para 14, page 41. The finding is this, per contra, learned counsel for the plaintiff would argue that defendants cannot represent the case as there is no proper authority, that will not skip. Next page, from about 5-6 lines from the top, if there is no jurisdiction, orders passed by the court would be a nullity.
Page 42 in the middle.
Middle. I'm sorry, about
The
7-8
bottom-
lines.
I mean, the middle, he would argue that the intention of the parties
Yes.
could be gathered from the
From
PPA,
PPA.
which
which
confers jurisdiction of the court at Bangalore.
Since the arbitration clause mentioned in the PPA was not specific about jurisdiction, and therefore the intention can be gathered from the PPA itself about the jurisdiction, and further commercial court at Bangalore has got coordinate jurisdiction over
commercial court at Ramanagara district by conferring the by referring to the notification issued by government of Karnataka dated so and so, wherein for the first time, two commercial courts were established, one in Bengaluru urban and one in Bengaluru rural district, and another commercial court for the purpose of districts of so and so, so and so. And Ballari and one at Bellari for some other districts of North Karnataka, and subsequently on 9/10/2019, as per notification dated so and so, for all district courts, commercial courts were established by designating principal district and sessions court as commercial courts. Therefore, from 9/10/2019, all principal and sessions court of the respective district would act as the commercial court for that district. Later, as per the addendum dated so and so, amendment is brought wherein it reads as Sarkarada Adhisuchane Sankhya so and so, so and so. So, with the help of the amendment, learned counsel for the plaintiff would argue that word shown as Bengaluru ನಗರದಲ್ಲಿ 2, ಬಳ್ಳಾರಿ ನಗರದಲ್ಲಿ 1 ವಾಣಿಜ್ಯ ನ್ಯಾಯಾಲಯಗಳಿಗೆ ನಿಗದಿಗೊಳಿಸಲಾಗಿರುವ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯನ್ನು ರದ್ದುಗೊಳಿಸಿದೆ ಎಂಬ ಪದವನ್ನು ಹಿಂಪಡೆದು ಬೆಂಗಳೂರು ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಗಳ ವಾಣಿಜ್ಯ ನ್ಯಾಯಾಲಯಗಳ ಕಾರ್ಯವ್ಯಾಪ್ತಿ ಉಳಿಸಿಕೊಂಡು ರಾಜ್ಯದಲ್ಲಿ ಎಂಬ ಪದಗಳನ್ನು ಸೇರಿಸಿದೆ.
Two things.
Please.
Either of that, if you show, that would suffice to bring.
Yes, yes.
One is cause of action, even a portion arises in Bangalore.
Please.
Second, alternatively, if you can show from the notification that the
Yes.
commercial court at Ramnagar as well as at Bangalore had jurisdiction.
Please.
Either
Now
of
may I-
those they show.
Second is
Yes.
the only point which is now what?
The first one,
First one is not there.
not as.
The appeal member is also not there. Second
One-
point is the only one which is there.
No, under the PPA, it is a court at Bangalore, which has.
I'll complete my argument. I'll complete my. Page 75. Lordships may seem, Lord. Page 75. The clause is titled as arbitration, but it is actually a dispute resolution clause. Page 75, Lord. Clause 20.
Right.
Dispute resolution, Lordships will see. 20.12, that last clause in that.
That's
The
right.
courts in Bengaluru shall have exclusive jurisdiction to settle any disputes which may arise in connection with the agreement. For the purpose, each party irrevocably submits to the jurisdiction of Bengaluru courts, waives any other jurisdiction, so and so, such other courts are situated wherever, irrevocably agrees that a judgment.
No, Srinivas, the agreement is at
There's one.
Bangalore.
Second point is,
Agreement is at Bangalore. This clause says, so wait, without getting into that notification also.
No, but because, so my point.
and second, sorry,
Now,
second,
now, only as per the agreement, just prima facie, yes.
But,
and Lordships
One
will
second, Sridhar Prabhu.
but the court finds, my lord, and it's not in dispute. The agreement was not signed at Bangalore, it was signed at Bidadi. But that's the finding of the court also. Therefore, my lord, the court also holds Bangalore, there is no cause of action arising.
Agreed for it.
But that, not the, insofar as agreement, but the law is settled not that two parties cannot confer jurisdiction in the court by agreement. Unless my lord, cause of action is arisen as part of it. But that's the trial court also
That's
finds.
fine. No, but one of the parties is in Bangalore.
No, no. Bidadi.
one of the parties is not trader.
One second. Page 54.
Please.
There is, how do you pronounce this? Commissariat Road.
Commissariat road.
Where is that? Vidadiya.
No, no, no. So far as not that is concerned, the lordship sees the primary dispute is between not the person at.
No, no, it's not about, they're only on territorial jurisdiction.
True, true, my lord. The lordship
One of
kindly
the-
sees.
See, there are. the
No, he is not a
tripartite-
party to the suit. Lordship sees not insofar as the person shown in the agreement is a trader. There is no dispute, not there is no cause of action pertaining to him. He was a trader. He only introduced the parties. It's a power purchase agreement.
No, all that is on merit. We are only on territorial
Please,
jurisdiction.
Lord, on territorial jurisdiction, Lord.
The document says executed at Bangalore.
Lord, that is not correct, Lord, because the court has found it was executed at Bidadi.
How?
But the mails, there are mails produced
No,
before
no,
the court.
all that is mixed question of fact.
No, Lord, the lordship says that is not in dispute. Lordship
We
says not.
can't- For the purpose of ascertaining, document ex facie shows Bangalore.
No, Lord, lordship
If
says.
you want to take a stand contrary to that,
Please.
that requires inquiry.
No, there is no dispute about it, no, because we have produced mails. That is not the point where it's before the lordship or even in trial court. Fine is not the
It's
main.
not about being urged. We are on
On the
territorial.
question of fact, let me just point. The lordship said, what the agreement says, it is executed at Bangalore.
Right.
But if the agreement is executed at Bangalore, not Bangalore court should have jurisdiction. But it was pointed out to the court, but
We can do. We can. I will find that it is.
holding that prima facie, the agreement shows territorial jurisdiction as Bangalore, frame issues on all aspects, including the issue regarding territorial jurisdiction, decide the issue with
On the
regard to
basis of evidence, let the court itself decide whether it has the jurisdiction or
But
not.
if I may just point, can we take to page 41 and 48 of the order? There is no dispute about that one. He also does not dispute a signed bidding. The mails which are made between the parties were produced before the court. He does not dispute it. Even the plague board does not say the agreement is signed at Bangalore. And when the mails were produced,
So did you say it is signed at Bangalore?
yes, no, I did not support. I did not support.
Did you say it was signed at Bidadi?
Yes, what is the mails? Can you see on page 47?
In your written statement,
But I have yet to file the written statement because I filed another application on
that's what my lord is saying. You file your written statement saying that though the agreement shows agreement is executed at Bangalore, in reality it was at Bidadi, and therefore territorial jurisdiction.
That's not in dispute. Not if I just point out. If the Lordship kindly sees the filed, then I filed these documents, not mails from the parties showing that the mails show it was signed at Bidadi.
He should have an answer.
After the court, he filed his written submissions. He does not dispute that. The only point urged to the court was not about the notifications. His contention not is that commercial court at
But
Bangalore.
we have the agreement in front of us.
Please.
Whatever, whether he argues or not.
That's not a point urged. The only point
No,
out. Once there's a
I just
finding-
want to know, we know about strategy, we know about what lawyers do, but what is the difficulty going?
But your Lordship sees if there was a dispute about it, but I'm not. But it's not just for the sake of
Srinivas, how far is Bidadi?
no difficulty at all. Lord.
Go there and finish on merits, no?
I'm not having no difficulty.
No, my lord.
No, go there and go to Bangalore only.
Oh, Bangalore next door.
Ultimately, Bangalore court has no jurisdiction. It's a question of territorial jurisdiction.
Why he?
He's located
It
at
is not
Bidadi.
as straightforward as you're trying to make it, because the document says,
But document, no doubt says that. And he's not.
the document says, the dispute resolution clause says Bangalore.
Bangalore.
So leave it at that, go to the Bangalore court and
But kindly turn to page 47.
Srinivas, what is the difficulty in trashing it out in the Bangalore court?
Point out what it does not have to. But he has recorded Bidadi.
Sir.
He's recorded Bidadi, not, I am not even.
Srinivas, I don't know if you're making it.
Plaintiff cannot choose his own place, but he has got the different place in Hyderabad.
He has challenged this on the grounds that the court has the jurisdiction.
Please not kindly turn to page 47. The order of the trial court. The bottom order at page 47.
Right,
Referring to the power purchase agreement, right at the bottom of the last line.
right.
Then it goes to the defendants refer some of the emails dated 27/11/2017, which reads as please refer to the scanned copy of the PPA which was held today at TTPA, underlined by me, sufficient. Please always use the original PPA. Factors of ensuring the authorized signatures in all the pages. This email was sent to the plaintiff, defendant, it was sent to Bidadi address. Now, after signature, it was sent back to Hyderabad. And the second mail is dated 27/11/2015, between 2 p.m. to 4 p.m. sent to the defendant, which also gives the draft PPA, draft final copy of PPA, and quantum will be supplied, etc. So all these means indicate the party transferred everything in Bidadi office of the plaintiff, and at no point of time they have come to the bank for the purpose of execution of PPA. So when they read these documents along with copies of the PPA, decision is set to 100% different, along with section 20 of CPC. And absolutely this court has no territorial jurisdiction to try the case. At the most, the plaintiff can sue the defendant either at Ramnagar, Hyderabad, or at the place of solar plant is situated. He has referred to the site map annexed to the power purchase agreement. It shows
Correct,
the
sir.
plant
This is without your written statement. This is based on document. Let what my lord is saying is,
May I just make one solution? But if you were to file an affidavit not stating, because even in the claim, it does not say it's
we are again repeating. How far is Ramnagar? What difference? Except for the fact that as lawyers we take up these contentions, in reality, so far as the resolution of dispute, how does it matter?
But ultimately, not territorial jurisdiction is the issue not which arises from consideration.
With consent, you can waive it. Section 21 is there.
But it's not. But the Lordship says not so much territorial jurisdiction, I cannot grant by consent. That is decision not for the Supreme Court.
You can't, is it? You can't.
Can I
No,
argue?
I cannot by consent also not. I cannot.
No.
The judgment of the Supreme Court.
We are not on conferring jurisdiction. We are on, if you don't raise it, isn't it waived?
But if I don't raise it at the earliest point of time, in appeal not under section.
Right. So we are not saying you give consent. What we are saying is we can go by the document itself.
The Lordship not says for the sake of not deciding the federal judicial court, I should file a written statement and it will be reconsidered. Not because not I only urge because they are not disputed this.
But
I pointed out the names.
the suit is not getting decided at all. We are only on territorial
I have no
jurisdiction.
decision. Not in fact, I have pointed out.
All
we
right,
can go to.
we'll put it to him.
They can go to Bidadi, my lord, I agree.
Go to
My
Ramnagar.
difficulties,
Absolutely.
I have lot difficulties. The lawyers that are engaged are from Bangalore. Now, personally, my lord, the client specifically kept this in mind when the agreement was signed and Bangalore my lord was conferred jurisdiction. Now, he also agreed, he waived other rules.
Then show us one particle or part of cause of action at Bangalore.
Yes, one is, my lord, the trader himself, page 2, though he is not party to it.
Right.
Kindly see his role. Yes, and
the
trading is a defined clause under
But
electricity.
he's not a
Act.
party.
No, he is not. But my lord, the trading, by why I am not suing him is also not explicit from the definition 271 of the Electricity Act. Keep 2 clause 71 of the Electricity Act. It says,
What does it say?
it says, my lord, trading means purchase of electricity for resale thereof, and expression of trade shall be constituted accordingly. He purchases and resells. So basically, my lord, I purchase from him, trader. So that is one aspect.
So
Second,
his place of business is at
Bangalore.
Bangalore.
Bangalore, no doubt.
The argument is he's not a party to the suit.
No,
So he's not a defendant.
No, he doesn't owe me any money, but my lord, necessarily that may, the agreement, for the purpose of agreement, he is a party to the agreement. Now, what confers the jurisdiction is, my lord, the agreement, not the dispute. I am saying if the agreement is, he is a party, that is one aspect. Secondly, my
What
lord,
about the notification?
yes, on the notification, my lord, lordships will see, my contention was not, is not negatived by the court that it has no jurisdiction. They say, my lord, I cannot possibly imagine that. May I show, my lord,
Which part of the
finding?
which part, assuming
Yes,
that the Ramnagar court alone has jurisdiction,
please.
then under the notification, can the commercial court at Bangalore,
Yes,
does it
yes,
have?
yes, my lord. That is what I will show.
If you
That
can
is
show
what I.
that, otherwise we'll have to remand it.
Yes, in page 44, my lord, of the order, on the reasoning part, they don't
Show us
negate.
the notification.
Yes, yes. Sorry. The notification is, my lord, I showed your lordships the notification at page number 200.
Right.
Which is, my lord, the true copy is 202.
202.
Yes, my lord, 202, wherein, my lord, individual. Annexure S, my lord, 202.
Right.
Individual, now, subsequent to those 3 courts being constituted, subsequently, my lord, every district got a commercial court. Now, this was the situation.
204, item number, serial number 24.
Yes,
Is Ramnagar.
yes, correct. 24, Principal Session Judge Raman. Now, what happens subsequently is, my lord, interesting. Page 206.
This is 9/10/2019.
Please, that is the situation obtaining on 9/10/2000. Now, subsequently, on 24/10/2019, lordships, it is in Kannada, because not, the translation may not be very correct, but I'll 206. I pray to read it in Kannada first. Not 206 annexure T. ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ so and so ದಿನಾಂಕ so and so ರಲ್ಲಿ ಲಾ so and so ಎಂಬ ದಿನಾಂಕ so and so ಸೂಚನೆ ಬೆಂಗಳೂರು ನಗರ 2 ಬಳ್ಳಾರಿ ನಗರ 1 ಕಮರ್ಷಿಯಲ್ ನ್ಯಾಯಾಲಯಗಳಿಗೆ ನಿಗದಿಗೊಳಿಸಲಾಗಿರುವ ಕಾರ್ಯಪ್ರಾಪ್ತಿಯನ್ನು ರದ್ದುಗೊಳಿಸಿದೆ ಎಂಬ ಪದಗಳನ್ನು ಹಿಂಪಡೆದು ಇದರ ಬದಲಾಗಿ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ so and so that was the first notification that conferred jurisdiction ನಿಗದಿಗೊಳಿಸಲಾಗಿರುವ ಬೆಂಗಳೂರು ನಗರ ಗ್ರಾಮಾಂತರ ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆಗಳ ವಾಣಿಜ್ಯ ನ್ಯಾಯಾಲಯಗಳ ಕಾರ್ಯವ್ಯಾಪ್ತಿ ಉಳಿಸಿಕೊಂಡು, that is what the English translation is, by retaining the jurisdiction. Please.
202.
Yes.
Notification.
Please.
Clearly says that Ramnagar commercial court has to decide.
Correct.
Has that been modified?
Yes.
On
That is what is
24/10?
modified.
Has serial number 24 in annexure S.
That is not modified, my lord.
Right.
That they have a concurrent jurisdiction.
Where do you get that?
Yes, that is, my
Where
lord.
do you get?
No, these jurisdiction is unaltered.
That has not been withdrawn.
No. Both can file. No. They can file in Ramnagaram. They can file.
So if your interpretation is accepted, all across Karnataka, this will happen.
No, my lord. That will, no, Ramnagara people will not be disturbed.
Not about Ramnagari. Your contention that
No. Consequences should not.
your contention,
Yes.
there are three notifications.
Yes,
The first notification is 31/7/18,
please.
followed by 9/10/19,
Yes,
followed by 24/10/19.
please.
You want to read all three together and say
Yes,
that notwithstanding 9/10/2019,
please.
the commercial courts at Bangalore
Yes.
have concurrent jurisdiction over all the courts shown in 9/10/2019. If you were to accept that,
Yes.
then all the net resultant position would be,
Ah.
there are about 30 districts in Karnataka.
Yes.
Commercial disputes all across Karnataka, Bangalore and those districts.
Yes, my lord. 193, page 193.
How is it?
No, 1 second. 193, that was the situation obtaining.
That was
Page
earlier.
193.
Yeah,
Yes,
that's
that was
right.
earlier. That is what-
Before designated. Cancelled.
It is ordered for me.
It is cancelled. Please read the 9/10/2019.
Yes,
It's cancelled.
9/10/2019. Yes, my lord.
Two Bangalore urban,
Yes.
one Bellary.
Cancelled, correct. That instead of cancelled, they have substituted these words. Instead, that is the substitution. Instead of saying, that is what, my lord, I read, that withdrawing the phrase, that is not the English translation, 208, in Kannada, himpadedu, that those words are withdrawn and these words are inserted. There is a conscious, my lord, insertion by the legislature, conferring back the jurisdiction to Bangalore courts. The withdrawal is withdrawn now, in effect. And this notification is not disturbed. 9/10, the notification continues. They do have the jurisdiction. In addition to that, the jurisdiction is retained. Otherwise, my lord, purposive construction rule will
How
get.
you read that?
That is, my
How you
lord,
read that it continues?
it is by virtue of the fact, my lord, it is withdrawing the phrase. In Kannada, my lord, the wording is Sarkarada Adhisoochane so and so ನಿಗದಿಪಡಿಸಿರುವ ಹಿಂಪಡೆದು ವಾಪಸ್. They have withdrawn that. And then my lord inserted these clauses, these words in
Now,
place of those words.
that means it is not in existence once withdrawn.
No, those words are withdrawn. My lord. Notification is not withdrawn.
No.
The words are withdrawn.
We cannot read it that way.
In government.
We cannot read it that way.
So much confusion.
Author clarify the intent.
There seems to be an ambiguity.
I just find out why
You
it
can
was done.
clarify that.
If I may just find out why it was done.
We cannot read it that way.
But the question is, why was this corrigendum introduced?
May I just point out, the first notification was at page 196.
Right. Right.
As per this notification, there were 3 commercial courts
That's right.
and they were given.
Two at Bangalore, one at Bellary.
Bellary. And there are various, city.
So let's understand it a little slowly. The first notification, 2 at Bangalore, 1 at Bellary. Cases all across Karnataka would either come to Bangalore or go to Bellary.
Different districts are allocated.
That's all.
Then
That's all.
the entire Karnataka was divided into 3 courts.
Three courts.
Yes.
Right.
But now we are asking the second notification, which is at page
202.
202.
Right.
In this one, what happened was trying to see what is word. English
Jurisdiction.
version. Jurisdiction designated to Bangalore urban and Bellary commercial courts have been cancelled.
That's my
Right, notification dated so and so. It is ordered to
They
following district.
clarify. They clarify.
It is ordered, yes, but I will point out why it was clarified.
No, we got it. See,
Because what happened is Bangalore courts also ceased to have.
no. Sridhar Prabhu. Yes, right. See, read at page 202.
Please.
Jurisdiction designated to Bangalore, the first 3 lines.
Yes.
That appears to be contrary to serial number 5 and serial number 3. There is some dichotomy or discrepancy there. That is not to be clarified.
Therefore, they clarified later on. So that for Bangalore, they continue to have this and additional courts at Bangalore. Not only
Please.
2 courts, but additional courts.
They cancelled Bangalore and Bellary.
Please.
But below, in the 30 districts,
Yes.
they included Bangalore and Bellary. Therefore,
Yes.
having withdrawn Bangalore and Bellary, in 910 and included in the table at serial number 3 and 5 gave rise to a dichotomy. That is sought to be clarified, correct?
Bangalore, you flooded all commercial courts, all the districts in Karnataka.
No, it won't be flooded. It will be not wherever they, no.
How do you know?
No, I am, but I am only.
Giving an option that defeats the very purpose of the commercial
No,
courts.
it's concurrent jurisdiction.
It can't be. Can't be concurrent. How can it be concurrent?
No, that is what, my lord, I
No,
read it.
That interpretation we can't accept. The only thing, the cause of action because of the agreement, we'll send it back based on, I treat it as a preliminary issue, decide it, and then you people sort it out. What else to do? But both of you are not ready to go to one court.
No,
And we can't compare both of you.
I am grateful.
You want to take instructions
I think,
so that you go to one court and this territory. See, otherwise what will happen is, we don't know how that finding on preliminary issue will go. It may go your way, it may go his way.
Unnecessary waste of time.
yeah, unnecessarily waste
Waste
time. It won't solve anything.
You also take instructions.
If my lord is insistent that he wants to come to
No, it's
Ramnagar
not about his insistence. He says, this is the law.
jurisdiction.
You can't confer jurisdiction by consent.
Right.
You are saying the agreement and other documents show
Yes.
that this court, trial court has jurisdiction.
Yes. I would only do this. As per the agreement, trader
You
argument,
take instructions.
I'll do.
Otherwise, we propose to remand it to decide the issue regarding territorial jurisdiction, redo it after inquiry.
That will be, my lord. I will seek instructions if I am ready to go
So
to
that is
Ramnagar.
fine. That is fine insofar as deciding the issue is concerned
Yes,
for the present. But
Yes.
for the suit will never progress.
that's. Lordship may have it 2 days, hence my lord, I'll seek instructions.
Monday.
People still, Monday.
Trying to say.
As well as learned senior counsel for the respondent jointly seek time to obtain necessary instructions in the matter. Released on Monday.
MB Act will be under the MB Act. These accidents. So the
I appear for the appellant in this matter, my lord. The senior counsel who has been briefed in this matter is out of station. I request your lordships to have it next week or the week after at your lordship's earliest convenience, my lords.
have you find objection?
I received it yesterday, man.
If there is no urgency after vacation,
Then the interim order may be, continued, my lord. The interim order granted on 10/3 may be continued.
or if you are saying urgency, we'll give a short date. 2 weeks, 7th, 8th,
8/4.
7th, 4th, Thursday. At request of learned counsel for the appellate, released on 7/4. Interim order granted earlier is extended till next date of hearing.
Much obliged.
Lord,
Unmute yourself.
Lord, I appeal for the respondent. Lord, we need a 2 or 3 days time, my Lord, to file a response to the interim application that has been filed seeking directions with regard to bank guarantee.
The only thing is that this bank guarantee arrangement was made by the trial court, by virtue of which they were granted a stay. The understanding was that 60% of the amount would be deposited and 40% would be by way of a bank guarantee. But that was confirmed by the Supreme Court. But even the interim arrangement went all the way to the Supreme Court. Now in the 34, I permission and withdrew, and my bank guarantee continues. Their bank guarantee has lapsed. That's the short point. Even after the reduced amount by the 34 court, there's still a shortfall that is due to me of over 22 crores. That's really where we are. So if my learned friend wants 2 or 3 days, I can't stand in the way. But any short date may be fixed because that bank guarantee that they had issued has lapsed. That's the only anxiety.
It lapsed in October, my Lord, during the pendency of the challenge, not after the order. 6/10, my Lord, the order.
It's not my case, sir. In fact,
Guarantee
it's so
expired.
specific.
Therefore, my Lord, I also intend to file a.
So that's what we're about to ask.
I'm sure he'll file an appeal.
I also intend to file an appeal, my Lord. There is a.
No, at least
I'm on the verge of filing an appeal because there is a finding already that it's the order award is perverse.
we thought compared to Indian Railways, Metro is fast, super fast, and you still not filed.
No, I still have time to file it, my Lord. It's in the process of getting not approved and all that.
Money is good, so I'm under the anxiety. That's the only thing.
At request of learned.
Anyway, they have withdrawn 100 crores, my Lord, which I had deposited.
There's far more money due to me. It doesn't mean anything that it's money due to me. I was made
At
to wait.
request of learned senior counsel for the respondent number 1, relist next Thursday.
Please. My Lord, sorry, 31, there's some difficulty. Could it be 29th or, my Lord, 4th? I'm great.
Fourth. Grateful.
Petitioner. Proceedings completed, my Lord, matters to be heard finally, my Lord. Proceedings are complete, my Lord. The date may be fixed for final disposal.
It is already fixed today.
30 years old.
June will give a date. Right. Right.
About 28 years old cause of action. Can that be entertained now? And the entire.
It is to be heard finally now.
The upper project. What is the Batre? What is the either?
Goma land, my Lord, is said to be acquired under the KDP Act and said to be de-reserved and given to so many other projects, my Lord, which is totally contrary to section 94 is the total sum and substance of the case, my Lord.
KDB has to. KDB. All right.
More than 15 years ago, possession was already handed over to the KDB. So it's not sought to be acquired.
Acquired, handed over, 2088, everything is over.
No, my Lord. The de-reservation order itself is of 2015.
2000?
Not 15 years back. It is 2015 de-reservation order by the government. It is thereafter, my Lord, in 2018 and 16, my Lord, notifications under 3.1 and 3.2 were published.
No,
That was
this
challenged.
1993 order.
There are several orders, my Lord. There are several orders. It is Goma land, my Lord.
The first order is 93 order is what?
That is also one other de-reservation order, my Lord.
So, The de-reservation happened in 1993.
Yes, my lord.
That's the first date of person. That's the first.
Yes, my lord.
You are villagers.
We are villagers, but land is,
Sir, you are villagers.
yes,
You are grazing cattle.
yes, my lord.
It is de-reserved in 93.
Yes, my lord.
And you stopped.
That was not within our notice, and no, I have said, my lord, in specifically made averment that despite the reservation order, it continued to be in a grazing land. The cattle are grazed there only. But only part of the land has been utilized and part of the land has not been utilized also.
First de-reservation, then after de-reservation.
The lands are, my lord, specifically reserved for a grazing cattle only, my lord. That has to be de-reserved, then only it can be given only for those purposes, my lord, which are specifically.
No. Ultimately, today or whenever,
Yes.
supposing we uphold
Yes.
the de-reservation order, Annexure F,
Yes.
then everything goes.
No, not everything.
Is it?
No, my lord. In that de-reservation order, only a part of the land. It is not the entire land. No, under the latest notification, whole land of the grazing land measuring about 258 acres is thought to be de-reserved. It is not only here. All over Karnataka, about 10,000 acres of land is thought to be reserved. I am not about that. I am only about my village, nothing else.
So your village,
Yes, my lord.
assuming we come to the conclusion that the 1993 de-reservation order in respect of subject lands is correct and proper, we'll put it either way. Supposing we quash Annexure F, the de-reservation order.
Annexure
Yes.
F, my lord, Annexure F is
Hear
only
us.
in respect to 20 acres of land.
Kindly hear us. You're concerned with 20 acres or more
No, I am more than that.
in your village.
In your village, my lord, it's about 358 acres total was there. The whole lot over the period, my lord, is thought to be de-reserved.
By
Thereby,
which orders? By which orders?
my lord, first is under Annexure F. My lord, next order is under Annexure L.
So series of de-reservation orders.
Yes, my lord. Series of de-reservation.
Series of de-reservation.
1993 was first, then 2006, then 2014. 2014. In
So
between,
we'll have to examine
Please.
each de-reservation
Please.
order independently
Please.
and then decide whether the de-reservation orders are correct.
Yes,
If we come to the conclusion any one of those de-reservation orders are illegal, that will impact your acquisition. Is that
So
the
far
correct
as-
position?
Section L, page 159.
We'll hear it. We'll hear it.
Line.
No, we just thought, if my lord and we were thinking that if 1993 is the only order, then we can test it right now.
it's not the only order. That is
We'll
only
get-
in respect of part of the
All right.
land about 20 acres.
June date.
His counsel informed that pleadings have been exchanged, matter is to be heard finally.
Right.
With the consent of parties counsel, this adjourned.
15/6.
Number 11.
And this have been listed, I don't know why. All area.
Correct. Till the board branch. I also tell the.
Yes,
I seek a short accommodation, because the instructions are there. I have to file objection. 2 weeks finally, my lords, I will file objection.
it is listed for preliminary hearing.
Yes,
You
my
have
lords.
not filed the objection.
Objections not filed, my lords. I have instructions are there, my lords. 2 weeks.
Learned AG informed that he has received instruction. He prays for the allowed 2 weeks' time to file the statement of objection. Give a date after 3 weeks.
But can it be after vacation, my lord? Because similar matter, my lord, arising out of, my lord, the same proceeding, my lord, the matter is
Only
pending
request
before
the
the
council
Supreme Court.
petitioner list in June.
2/6.
Please.
Much obliged.
Number 12. To Rajshekar is-
It's also, my lords. Earlier occasion, my lords.
Yes, time is granted, my lords. One more chance, my lords, I am seeking. Assistant Commissioner could not come because His Excellency Governor is visiting their place. He has to sign the affidavit. Next week,
Time.
please.
So finally, statement of objection is directed earlier.
Great.
230. CM Nanjareddy.
No urgency, no cyber, but the cases are listed.
ಯಾವ್ದು ಕೆಲವು ಮೂವ್ ಮಾಡಿರ್ತಾರೆ ಅಂತದೆಲ್ಲ
What to do? He is not there. Petitioner.
He is there, sir. And we see Mr. Nanjareddy.
Milord, I am for the petitioner.
Yes. What is the
Milord,
matter?
Milord, this is the material Milord supplied. I have paid the Milord, the petitioner is the Milord acquiring leaseholder. Milord, he has paid the royalty. And also Milord, through bills, Milord, government has deducted the Milord royalties twice. Therefore, Milord, I am not liable to pay any royalty, Milord, as demanded by the Milord, the respondent state. This is only for year
Is there any
2017-18.
interim order?
There is an interim order.
It was only a notice.
50% I have deposited the amount. Milord, the rest is state because this has to be considered. Milord, you last may have it after vacation, Milord, so that I will file the other.
50% on his own. The petitioner failed to deposit 50% deposit. Yes, what do you say? Hmm. 13/1/2022.
Still have to either amend it or challenge it.
Challenge it. Sorry. We have already passed such orders. Yes.
Milord, they have only Milord, they have not filed the objections to the petition. Milord, traversing the Milord, Milord, the petitioner's claim. Milord, unless that is met, Milord, this is only for 2017-18. When there is an interim order, Milord, the remaining 50% also they have included for the 17-18, and Milord, another demand has been issued. Now, Milord, they have to file objections to the Milord, contentions raised in the writ petition.
That is included. That is included in this.
Annexure G, Milord, page 71.
13/1/2022 demand notice includes that period also, and therefore you will have to challenge this. You have a statutory remedy against.
No, when there is an Milord, when there is an interim order of stay, Milord, they can't include Milord in the demand notice. Milord, various contentions are raised.
We have already discussed the similar matters, saying that you go and avail the statutory remedy as may be provided under law against this order.
That is true. This is only what I am saying. This honorable court passed an order. Milord, the twice, Milord, the amount cannot be, Milord, royalty cannot be.
What is the copy of that order?
Annexure. I have produced that order.
We have
Annexure Y.
Said that due to subsequent pendency of this writ petition, subsequently a fresh demand notice has been issued in which the period under the impugned notice is also included. Therefore, now the writ petition is not maintainable and he has to challenge this.
It amounts to contempt. When there is an interim order, they can't include. Only 50% they again, Milord, they have included and issued demand notice.
Subsequent period is also there. Where is
that's true, Milord. I am not saying. Milord, this is Milord for the Milord. Milord, I request Milord, last may kindly consider this, Milord, the various contents raised in the writ.
So what we can say that you may challenge this.
Annexure Y, Milord, is the order of this one. My own material, I am supplying, my lord, and the bills they are deducting.
Challenge this.
Nothing survives because of this revised demand letter dated 13/1.
Lord Counsel for the petitioner, the writ petition was filed in the year 2019, seeking following relief. During pendency of the writ petition, the respondent have issued fresh demand letter dated 13/1/2022 regarding payment of arrears, tax on querying lease number 920 for the period 2017-18 to 2019-20 revised and 2020-21, and regarding rectification of the condition of the lease deed and submission of necessary statutory documents. In view of the subsequent development, the writ petition does not survive. It is accordingly dismissed. However, with liberty to petitioner to avail the remedy as available to him under law against the demand letter dated 13/1/2020.
All contentions kept open. No opinion because there if it was.
All rival contentions are kept open and no opinion is expressed on the merit of the case.
God bless.
Amendment of petition is not carried out. Aspect. What has happened? Not the earlier 2018, in year 2018.
To amend, you have to amend the petition.
Please, I will amend. I have filed the amended first title because of that, that earlier period. Not on submission.
For petitioner pays for is allowed 3 days time to carry out fiscal amendment in main writ petition.
Please, I will amend.
Next week.
What accommodation to find rejoinder in this matter?
Counsel for petitioner pays for is allowed 2 weeks time to file rejoinder affidavit to the statement of objection filed by respondent.
Interim order.
Instead after vacation, my lord.
That should be continued.
What time we have taken?
Interim order granted addition shall continue till next date of listing exhibited. Next.
Affidavit is not filed. In rejoinder, affidavit is not filed.
Rejoinder without affidavit is not maintainable.
Each time will be granted.
Counsel for petitioner pays for is allowed to make good the objection raised by the office. Give a date. Next.
I don't appear for the petitioners. But petitioners in this case are challenging the route proposed by the respondent corporation, my lord, which can be seen at annexure F, my lord, internal page number 194 of the petition. My lord, your lordships may also kindly see the map produced by the respondent corporation, my lord, produced along with the memo for additional documents.
Yes.
Basis of the challenge is to land that is being constructed. Whereas the apprehension of the petitioners is that this will aggravate the problem of pollution. Whereas in fact, I will demonstrate to your lordship that this is actually a problem that we are trying to solve by means of the work in petition. Because we have found a route which is the shortest possible way to evacuate by ash from the ash bomb. And the route is the one where there is no And then my lords, there is a bridge across the river through which they try to evacuate the fly ash. So no, I want this request to lords not to take the map, because we use a Google map along with the memo. This is the best possible solution. Evacuate fly ash. Now, as far as the other aspects are concerned, I will be responding on that as well. The main challenge is to the construction of an approach for evacuation of fly ash from the ash form. Use this Google map.
Yes, it is before us.
Other Google images.
Last minute.
For evacuation.
Yeah. नहीं उधर नहीं है ना नहीं
Right.
Right. Read from this, no?
This is in black and white, so we couldn't. No. Root one, blue color, 20% brown. Technically, I also. What remains? What exactly is fly ash?
Fly ash is the byproduct that is formed when coal is going to the there are small fine particles that settle. Those have to be evacuated. There are details.
It causes environmental pollutions. So it has to be taken because it is very light in the way. So it has to be taken in the closed containers. Closed containers.
There is no dispute about the fact that they are being taken out in closed containers. We also have other measures to make sure that there is no leakage at all. There are closed tarpaulins. All the vans that evacuate fly ash.
Now this fly ash is also being used in the building material. Probably.
My lord, fly ash is also being used for road construction as well as for cement raw material for the cement manufacturing.
And second, cement companies use it. They're the largest bulk consumers. They use it in the manufacturing of
Cement.
dangerous commodity is actually being evacuated and is being used for medication purposes.
Thermal plants and
Byproduct being used by cement companies.
Closed containers transported in. Yes.
This picture, I can just show what the events of the petitioners is. Because they are residents of two villages, which are will find on the right hand side of the village. Neighbors are one village and RTPS colony. They are inhabitants of these two villages. And they believe that the evacuation of fly ash, which passes through a road that is close to their villages, will create issues for them. So, it is in fact in response to these grievances that we have.
Just 1 second. This Raichur to Hyderabad is a national highway, is it?
Yes, yellow color.
Right. So they are to the right of the national highway. To the left of the national highway, you have the ash bund.
The ash bond and the thermal power plant.
And their grievance is that the fly ash from this ash bund is not being disposed of, thereby causing air pollution.
Transportation.
Evacuate fly ash from the ash pond, take it to Hyderabad where 80% of the fly ash is being utilized by cement companies. And their challenge is to the construction of this ramp, which you find there is a green arrow which evacuates the fly ash from the ash pond. The last arrow is the ramp. This takes the ash from the ash pond towards Hyderabad. Actually away from their roots.
Construction of this ramp is what they have.
How it is affecting the residents?
It's not. It is not. Which is exactly the point that we would like to convey to them. Because this ramp completely avoids their villages. It goes. It's the farthest possible point from the ash pond.
Yes, it is after the villages.
It's after the villages, and therefore they can have no apprehension at all. This Dev Circle village is around 4 kilometers away. RTPS colony is around 2 kilometers away. And we have taken every single precaution to make sure that all the vans that evacuate fly ash are closed.
That it should be removed rather than to object to the ramp. What is the point?
I mean, two submissions, my lord.
Yes.
My lord, petitioner's grievances not with respect to the evacuation of the or the transportation process. Petitioner's grievances with respect to the consequence of transporting the fly ash from ash bund 1 to connecting to National Highway 167. My lord, may I make one more submission?
How you are affected?
My lord, I will explain, my lord. Your lordships may kindly see the route highlighted in red color and as well as the route highlighted in blue color, my lord. These are the two existing routes which the respondent corporation is transporting fly ash from the ash bund to connecting to National Highway. My lord, now the issue here is when fly ash is transported in the trucks, my lord, it spills over the National Highway and it spills over the road and it easily mixes with the dust, my lord, and it is transported through the air to nearby homes and indoor environment, and thereby it is causing pollution and thereby it is affecting the right of the petitioners, that is healthy environment. That is the grievance of the petitioners.
Suppose this ramp is created,
Yes, my lord.
ramp is constructed, and through the ramp it is taken, then it will not be taken through the old routes. Then it will not come near to the villages.
The existing routes are more harmful to you.
Yes.
My lord, if your lordships may kindly see the right hand side of the junction where green arrow mark meets with the yellow color National Highway, my lord, right hand side just adjacent to the highway there is a residential area, my lord. Petitioners have informed us.
No, you don't want them to go towards Hyderabad.
No, they can take alternative route, my lord, not right hand side of the ash bund 1. They can take the left turn of the peripheral bund of the ash bund 2 and they can come to that blue color highlighted path Jackwell.
That's the river.
No, my lord. No, my lord. At the junction point, ash bund 1.
The highway goes towards Hyderabad.
Yes, my lord.
They want to construct a ramp. The existing two routes are closer to your villages. They want to go further away from the villages.
No, it is not far away from the residential area, my lord. It is just within 1 kilometer range. That is what the petitioners have informed us. And your lordships may kindly see the roof, which is adjacent to the houses which are adjacent to the yellow color highway.
If they don't go ahead with this ramp and they use the old route, still they can go through the highway. They can still go to Hyderabad. No?
Same place.
But the ramp, my lord, connecting from the ash bund 1 to green yellow color highway, that is the issue because petitioners are using that service road to go to the Krishna River, my lord, for holy purposes. That is again one more issue, religious issue, my lord, which is concerned here.
We have to see the larger public interest. Now, if they use the old route, it is more dangerous to the residents who are nearby than the route if the ramp is constructed.
My lord, they have alternative route, my lord, which they can take it from the peripheral part of
for the religious purpose, you may be using for some time only that nearby road to the ramp. But this road is continuously used, the old route. And therefore, if the old route is allowed to be used for the removal of this fly ash, then it is more dangerous.
On one hand, we have few of them using it for religious purposes.
Larger interest is that the ramp is created and fly ash is taken from that one.
My lord,
Most.
I have one more submission to make in addition to this affecting to the environment and as well as the people residents of the Devsagur village. One more submission is that, my lord, as per Annexure RA produced along with the statement of objections, my lord, and as well as section 28 and 29 of the Control of National Highway Land and Traffic Act of 2002, they have to seek consent, my lord, to access national highway. The consent has not been obtained, my lord, to.
That they do.
They
one submission,
will
my
do
lord.
it as in accordance with the procedure or the rules, whatever is prescribed. That
My lord.
then we will provide. We'll dispose of this.
Last submission. My lord, may I make last one submission? With regard to pollution control findings, my lord, with respect to the.
All these petitions are filed against the public interest.
My lord.
We don't understand why you people create such problems.
My lord, may I make a small submission on behalf of respondent number 4, Karnataka State Pollution Control Board? Because incidentally, I have worked in Karnataka, that thermal station, Raichur thermal station as engineer. And incidentally, I am from Raichur. And I also worked in 7 thermal stations, super thermal stations. And here, the thermal station has existed. Thereafter, the settlement has been made illegally by the villagers, these petitioners, as could be seen, petition number 12. He says, Shakti Nagara Ulisi Horata Samiti. They want to save the Shakti Nagara. And further, Guttige Karmika, serial number 4, petition number 14, Guttige Karmikara Sangha is a representative. See, they are all having personal interest. They want the contract for the shifting of the ash for themselves, which they could not.
All right. In this public interest litigation, petitioner is sought for the following reliefs. Third, learned counsel and learned senior counsel for PPCL, is it? That's right. For respondent number 2 and 3, as well as learned counsel for respondent number 4 dash Karnataka Pollution Control Board, and the learned AGA for respondent number 1, and peruse the material on record. In addition to reiterating the various contentions urged in the petition and referring to the material on record, learned counsel for the petitioner made the following submissions. One, the proposed construction as per the impugned, what is Annexure F?
Annexure F is the tender notification.
The proposed construction, shall we call it a ramp? The proposed construction ramp pursuant to the impugned tender notification by which the fly ash generated, fly ash is the byproduct of the power generated by KPCL, Raichur Thermal Power Plant, would result in environmental hazards, in particular air pollution. And consequent air pollution when the same is transported through the ramp.
When it is transported through trucks from the Ashburn 1 to connecting to National
Highway.
Highway.
Ashburn connecting to the National Highway, which connects Raichur to Hyderabad, and therefore the impugned tender notification deserves to be quashed. Secondly, it is contended that the petitioners are residents of the adjoining villages, that is Deva Sugar and RTPS colony, and that the petitioners as well as other residents of the villages would be put to great hardship and prejudice if the fly ash would be transported pursuant to the ramp constructed as per the impugned tender notification. Thirdly, it is contended that the villagers are using the service road adjoining the national highway for the purpose of religious activity. And if the fly ash were to be transported through the proposed ramp connecting national highway, the religious activity of the villagers would be interfered with. And on this ground also, the impugned tender notification deserves to be quashed. Isn't it? Per contra, learned senior counsel for KPCL, in addition to reiterating the various contentions urged in the statement of objections and referring to the material on record, invites attention to the Google map depicting the topography of the area in order to
And the actual location.
and the actual location
of
the existing / actual location
of
of
ramp.
the KPCL Raichur thermal power plant, Ashbund 1, Ashbund 2, National Highway connecting Hyderabad and Raichur, as well as the full stop, the existing route number 1 and route number 2, through which the fly ash is presently being transported, and also the proposed ramp, in order to contend that by virtue of the proposed ramp constructed connecting the national highway, the fly ash which is presently closer to being transported closer to the village, aforesaid villages where the petitioners are residing, would be transported at a further distance, is it? At a farther distance. And consequently, rather than creating any air pollution or hardship to the petitioners and the other villagers, the fly ash would be safely transported on the national highway through the proposed ramp to be constructed pursuant to the impugned tender notification. It is also submitted that when the religious interest of a few villagers for the purpose of carrying on religious activity is pitted against larger public interest by constructing the proposed ramp and by enabling transportation of the fly ash on the national highway, the larger public interest would prevail. And on this ground also, there is no merit in the petition and the same is liable to be dismissed. Then
Covered.
Closed containers.
Right. It is thirdly, it is submitted that all the fly ash is being evacuated through by closed containers after taking necessary clearances, precautions, etc. And no hardship, much less any prejudice or loss would be caused to the petitioners and other villagers if the proposed ramp were to be constructed by transporting, for the purpose of transporting the fly ash through the national highway, isn't it? Right. It is lastly, it is submitted that that pursuant to completion of the work in terms of the impugned tender notification, the respondents 2 and 3 would take all necessary steps and obtain all clearances, permissions, etc. in accordance with law. It is therefore submitted that there is no merit in the petition and that the same is liable to be dismissed. Full stop. Next para. Per contra. So also learned counsel for the Pollution Control Board and learned AGA for the state would adopt the submissions of the learned senior counsel for the KPCL and submit that there is no merit in the petition and the same is liable to be dismissed. Next para. We have given our anxious consideration to the rival submissions and peruse the material on record, in particular the Google map produced by the KPCL along with the memo dated 9th March 2022, which depicts the existing location, what do you call it? Location, topography of the KPCL power plant, the Ashbund National Highway, the villages, etc. Full stop. As rightly contended by the learned senior counsel for the KPCL, the proposed ramp constructed pursuant to the impugned tender notification will not only enable the KPCL to transport the fly ash from a distance farther than the existing route, but will also ensure that no air pollution or any other pollution would be caused to the petitioners or residents of the other residents of the villager, aforesaid two villages. Full stop. So also the submission of the learned counsel for the learned senior counsel for KPCL that the respondents 2 and 3 would transport the fly ash in sealed containers, closed/sealed containers. Sealed, is it? No. Closed containers, and also take all necessary precautions, clearances, etc. for the said purpose is placed on record. Full stop. It is also relevant to state that apart from the fact that the religious practices which are alleged to be affected by permitting the proposed ramp to be constructed, shall we say that? Not. It is also relevant to state that when larger public interest by way of permitting the proposed ramp to be constructed for the purpose of transporting the fly ash is pitted against the interest of some of the villagers who intend to carry on religious activities by using the service road which is connected to the national highway, it is needless to state that the larger public interest would prevail, particularly when the same concerns air pollution, which is sought to be taken care of by the respondents 2 and 3 by taking necessary steps as indicated above. Full stop. Under these circumstances, we are of the considered opinion that the impugned tender notification does not warrant interference by this court at annexure F dated so and so, does not warrant interference by this court in the present petition. Full stop. So also in view of the fact and circumstances stated above, in particular the undertaking given on behalf of the respondents 2 and 3 that the fly ash would be transported after taking all necessary steps in accordance with law, the other reliefs sought for by the petitioner also do not survive for consideration. Accordingly, the petition stands disposed of. Dismissed.
Interim order vacated.
And consequently, the interim order
vacated.
So and so 18/3/21 stands vacated.
Obliged, my lord.
The removal of fly ash was stayed by the court. Dumping was allowed.
The respondent number 7 was directed to file statement of objections for 4 weeks.
Ramesh, counsel for respondent number 7 pays for allowed 2 weeks for the time to file the statement of objection as directed earlier. List thereof.
The petitioner. Respondents were directed to file the objection on 24/9/2021. 4 weeks time was granted.
Counsel for respondent pays for allowed 2 weeks time for the time to file the statement of objection.
And they have it after vacation.
20, my lord, I am appearing for petitioner's counsel, my lord. There are 3 matters connected, my lord. The last occasion, I filed an application for amendment, which came to be allowed, and amended petition we have filed. But manual amendment is, my lord, yet to be done.
Petitioner pays for is allowed a week's time to carry out the.
My lord, I seek for dispensation of that manual amendment because it's a lengthy process.
We are granting you time 1 week.
Now, separate amended petition have already been filed.
That is not possible. You will have to carry out. You cannot dispense with.
In the meanwhile, government advocate be directed to file the counter mail.
All right, you carry out the physical amendment. We direct. Be time to carry out the physical amendment in the body of the petition List after 3 weeks. In the meantime, the AGA may file the statement of objection.
Advocate on record has issued NOC. Advocate on record has issued NOC, and I undertake to file NOC wakalat on behalf of petitioner. Some time may be granted.
It is submitted by so and so
After vacation.
that he has been instructed to enter appearance on behalf of the petitioner. Submission is placed on record, list after vacation.
22. Yes, you can take it off. Someone could directly produce sale deed to apply for registered copy of the sale deed and to produce the sale. But I got the certified copy. And the certified copy is the very same sale deed as that was produced by the respondent in the before the writ petition.
You are the LRs of the original grantee.
Original.
The first sale was 1978. And when
First sale was of the year 1950.
50. All right, the last sale,
One day.
only one sale. No, 25/4/1978 mistake.
78.
Grant was made in the year 1950. There are words
Grant in favor of
A.K.
Muniga
Muniga, who is maternal grandfather
of the petitioner. So A.K. Muniga's daughter,
Yes.
son-in-law Veerappa,
Yes.
Veerappa's children, you are Veerappa's children.
Daughters.
It doesn't matter.
Yes.
LRs of the original
Yes,
grant.
tell us.
First sale 19. When did you file the application before AC?
Objection.
2007.
Would delay reasonable time principle. The petition application before the assistant commissioner,
2007. 2007.
2007. Learned single judge has followed Neckenti.
One second. Before the assistant commissioner and the deputy commissioner, that sale was not questioned. The entries that continued in the name of the original
So
grant.
not entries. Shows the application filed by you for restoration before the assistant commissioner. Where is that petition?
Yes. Annexure A.
Annexure B is the order. Order.
Annexure B is the order of the
Is the order.
assistant commissioner.
Right.
Here, Last may kindly take that page.
No,
40.
annexure E, PTCL Act.
Yes, sir. PTCL Act and the actual question that was that
One second, one second. Re-establish. So this is a petition under section 4, is it?
4(2).
Petition under section 4
Yes,
filed before the assistant commissioner in 2007. Act came into force on 1/1/1979.
that is correct. My submission to your lordship is that no such sale was challenged before the assistant commissioner. In the year 1995, the entries which were in my name has been transferred in the name of.
Sir, one second, sir. Assistant commissioner application you filed, no?
Yes,
This shows that application.
yes.
Whether the prayer was for,
Application we are not produced.
No.
Only the order copy we have produced.
whether the prayer was with regard to cancellation of the sale deed and restoration of the land,
Yes.
or for change of kata.
Change of card. Ready, last may kindly turn page
Sir,
47.
page 48.
47.
Application to re-establish the land. These are not mutation proceedings. These are proceedings under the PTCL Act.
47 operating.
Huh.
47.
Right.
May I read?
ಹಿಂತಿರುಗಿಸಿದೆ.
ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಶ್ರೀನಿವಾಸಪುರ ತಾಲೂಕು so and so ಕಸ್ಬಾ ಹೋಬಳಿ
What happened before the DC? What happened?
ನಂಬರ್ so and so ಜಮೀನು ಸರ್ಕಾರದಿಂದ ಯಾವುದೇ ಪೂರ್ವಾನುಮತಿಯನ್ನು ಪಡೆಯದೆ ಎದುರು ತಮ್ಮ ಪರವಾಗಿ ಪಡೆದಿರುವ ಪ್ರಸ್ತುತ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ಪರಿಶಿಷ್ಟ so and so ಹಲವು ನಿಯಮಗಳ ನಿಷೇಧ so and so ಅಸಿಂಧು ಎಂದು
The DC reversed it, is it?
DC also confirms the same. DC also confirmed. And
the ALNE filed the writ petition, is it?
yes, my lord, he filed writ petition. First time he produced the sale deed before this honorable court. Before AC and DC has not produced any such sale deed.
What difference does it?
There before AC and DC, sale deed was not at all questioned. Sale deed has not been set aside. Only the entries which standing in my name that has been my lord, confirmed only.
But you don't dispute the sale deed.
See, whether it is cancellation of the sale deed, it may not have been correctly done as per what has to be done. But come to page 60.
Yes.
Khata without obtaining permission is declared as null and void.
Yes.
Under the PTCL Act.
Yes.
Not under the Land Revenue Act.
Yes.
So under the PTCL Act, the Khata, because it is in contravention of the Act, is rendered null and void.
ಅಲ್ಲ ಪಾರ್ಟಿಷನ್ ಅಂತ ಹೇಳಿ ಮಾಡ್ಕೊಂಡು ಪಾರ್ಟಿಷನ್ ಅಂತ ತೋರಿಸಿ ನನ್ನ ಹೆಸರಲ್ಲಿ ಇದ್ದಿದ್ದ ಖಾತಾನ ಅವ್ರ ಹೆಸರಿಗೆ ಚೇಂಜ್ ಮಾಡಿ. That is my last my kindly tell page 60.
There's a little difference. There's a little difference.
No, my lord, may I make one submission? Entire initiation of proceedings under the PTCL Act only. It was not under the Land Revenue Act. My lord, section 4(2) also my lord says any entry or proceedings under section 5. It is one and the same. One and the same. One and the same. Yes. It is my lord's court single judge has found that it is a enormous delay. Now you cannot seek that on the applying the Supreme Court decision. My lord's number of decisions, not that.
Page 99, you last my kindly term.
Whether actual nullification of a sale deed or any proceedings alleging contravention of the PTCL Act, if it is not filed within a reasonable time from the either the date of the alienation or the date of the transaction or from the date of commencement of the Act, Supreme Court has said within reasonable time those proceedings have to be rejected.
The
So
actual
1978-79 January 1st Act came into force. The transaction pursuant to which the Khata got changed was earlier to 1978. That you can't
the
challenge.
khata changed in the year 1995. Last may kindly take page 99. Page 99.
Right.
The typed copy is next page, page 101. 99 ಅಲ್ಲಿ ಏಕೆ ಮುನಿವೆಂಕಟಪ್ಪ ಮುನಿಗಾ ಬಿನ್ ಕದಿರಪ್ಪ ಇದ್ದಿದ್ದು ವೆಂಕಟಪ್ಪ ವಿಭಾಗದ ಮೂಲಕ ಅಂತ ಅವ್ರು ವಿಭಾಗ ಅಂತ ಹೇಳಿದ್ರೆ
ಮೇಲ್ ನೋಡಿ ಮುನಿಗಾ
ಮುನಿಗಾ RR 439 ಅದು RR end.
There is a little difference, Vijay Kumar. It was granted in favor of Muniga.
Muniga sold it.
Muniga, he says partition.
Oh, Muniga sold it to Virappa.
No, Muniga, Vibhaga. Vibhaga is partition.
Okay.
It's a mistake.
They are produced first time in 2000.
Para 8 of the finding, my lord, learner single judge finding. Para 8 of the finding of the learner single judge refers us.
even deputy commissioner and assistant commissioner insisted he has not produced. Deputy commissioner also made observation in his order
But if
that
the sale deed was there, it will not make any difference whether it was produced before the deputy commissioner or assistant commissioner or not.
We are also trying to understand if there is a registered sale deed dated 25/4/78, pursuant to which there is a Vibhaga, merely because you don't challenge that sale deed, but still invoke PTCL Act after reasonable time, that we can't interfere.
Para 8 is very clear, single judge order.
Right.
Very clear. Subsequently, they partition, and then they come claim on the partition.
Purchaser partition.
Yes.
Purchaser partition ಅಂತ ಅವ್ರು ತೋರಿಸ್ತಿಲ್ಲ.
He has got his partition.
Yes.
Hereafter, partition was effected between the family members of the.
No, but do you agree that sale deed is there?
We have applied, my lord, in the encumbrance certificate, they issues that there is no such sale deed. But in a application, my lord,
The form 16 ಕೊಟ್ರೆ ಬರಲ್ಲ. Form
Form-
15 ಹಾಕಿದ್ರೆ
ಅದು ಬರ್ಲಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ಬರ್ಲಿಲ್ಲ.
ಇಲ್ಲ, ತೋರ್ಸಿ.
ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ annexure.
Whether that sale deed is there or not. Sale deed ಇದೆಯಾ ವಿಜಯ್ ಕುಮಾರ್?
ಮೆಮೋದಿಂದ ಕೊಟ್ಟಿರ್ಬೋದು. Page 109, page 109 ಮೇಲೆ ಅವ್ರು ಈಗ ಅಪ್ಲೈ ಮಾಡಿದಕ್ಕೆ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪೀಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಎನ್ಕಂಬರೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ. And my lord, before the authorities, they are not produced.
If you admit the sale deed,
He's not denying it.
you're not denying the sale deed.
That sale deed has to be questioned, my lord, whether because the person who has executed the sale deed as per the recitals therein, it is by, my lord, a person namely.
You have to test the finding of the learned single judge. Now you have to establish that there was no sale deed. If this is your contention, then all right. Otherwise, what is the material before us to say the order is bad? Learned single judge has taken note of the fact that the sale deed 25/4/2017 was made, and thereafter the partition took place in between the family members of KV Virappa.
On the minute till 1995 minute, the interest minute continued in my name only. Though the sale deed states that minute it was executed in 78. Right, no such entries have been transferred in the name.
Entries will not confer any right.
The portion also continued in my with the friend only.
We can't differentiate between a case where the LRs of the grantee challenge the sale deed and the case where the LRs of the grantee don't challenge. Doesn't make a difference. Reasonable time is reasonable time for the purpose of the act. That is the problem.
So
Thing can be
plus
done.
because the sale deed that indicates
So
that
whether it is
it was
produced as annexure A, the writ petition.
ಅದೇ ಇದ್ರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ annexure A.
They have produced.
Yes, minute. Whatever the deed they have produced, the very same copy we have produced in the appeal memo. And there it indicates that it was executed by Upparpete Kadrappan Maga ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ದಾರೆ. Page 35 minute. For fifth line. And he is A.K. Muniga, but here it is executed by Upparpete Kadrappan Maga Muneppa ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ದಾರೆ. Because the conduct also the not producing.
Very simple. Muniga is a grantee. This sale deed is executed by Muniga? No.
Yes.
By Muniga himself. Is it?
Yes, finding is the same one.
So let's read the document.
Yes.
Finding
This deed, Muneppa, son of Upparpete Kadirappa.
ಅದನ್ನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿರೋದು ಅವರು ಸರ್. He is A.K. Muniga in all grant records and parties indicates that he is A.K. Muniga.
A different person. for respondents 1 and 2, emergent notice to respondents 3 and 4, 3, 4 and 5, 3, 4 and 5, list after service of notice.
Got for interim. Both the AC and DC, the orders are in my favor. That orders have been reversed.
That's all. Your application is rejected.
My application is rejected.
So if we stay the learned single judge's order, that will revive. So we can't pass that kind of.
Pursuant to those orders, the revenue.
ACDC's orders would revive. We'll hear them and.
Yes.
Actually.
Uh, 23.
For the respondents.
This is a matter where the learned single judge note has modified an order of the assistant commissioner, which also was not before the learned single judge. The order note of 2005 rejects the application of the petitioners for resumption of land under the PTCL Act. But not an additional order is passed by the assistant commission, which in my respectful submission is clearly void, saying you must acquire the land and hand it over and pay compensation to the original grantees. Who have, can I request not to look at the order of 2005?
My lords, may I make a submission? My lords, I would want to file my objections to the appeal. I pray for a week's time, my lord. I'll file my objections and make my submissions, my lord.
Madam, what we propose to do is we'll set aside this because it goes beyond the scope of the petition.
No, my
and
lord.
we'll bring the matter back to the learned single judge. For
My lord, the state has already acted upon the order. That is what I would like to submit. I would like to produce certain documents with regard to the same, my lord. A week's time may kindly be granted, my lord. I'll file my objections.
Then we'll have to stay this, madam.
Please, my lord.
We'll have to stay the impugned order.
Yes.
Heard Shri Dhyan Chinnappa, learned additional advocate general for the learned senior counsel and additional advocate general for the appellant, and peruse the material on record, including the impugned order passed by the learned single judge. In addition to Ella Bardavitto, learned senior counsel submits that the learned single judge committed an error in traversing beyond the scope of the petition before him, and this has resulted in erroneous conclusion, warranting interference by this court. Full stop. Per contra, learned counsel for respondent. Respondents.
1 to 3.
All the respondents, is it?
Yes, madam.
All the respondents, madam?
Yes, madam.
For the respondent.
She's not appearing for all the respondents. She was only appearing for the petitioners. 1 to 3.
1 to 3. 1 to 3 seeks time to file objections. Full stop. Issue emergent notice to respondents.
She also permitted to serve the counsel not to appear for all the respondents.
Issue emergent notice to respondents 4 to 61. Appellant also made it appellant. Appellant also permitted to serve learned counsel for respondents 4 to 61, who represented them before the learned single judge, represented them in the writ petition before the learned single judge, released in June. Meanwhile, the operation and implementation of the impugned order dated so and so of the learned single judge is stayed till the next date of hearing.
16th June.
Uh,
24.
I appeal the petition. This is a matter, my lord, wherein your lordship may kindly call this matter on 31st, my lord. The learned senior counsel, my lord, who is arguing senior counsel is not in town. Your lordship may kindly take it up next week. 31st.
Counsel for petitioner. List after vacation.
31st, my lord.
After vacation, we have to hear the main matter.
25.
The petition has become infectious. The prayer sorted here is for order of conversion of land.
Counsel for the petitioners also makes a statement at the bar that
you're filing a memo, is it?
The petition has become infectious. The memo filed in this regard is taken on record. The petition is accordingly discussed. as having become infected. No, withdrawal.
Number 26.
My lord,
Order.
I appear for ninth respondent, my lord.
Give it date.
My lord, kindly
Article
grant.
IG 1 of 2 and 22. List on such and such date.
19-4.
This was of.
Much of.
Number 26. Sharda Bai.
Your Lordship, I'm appearing as a petitioner in this matter, Your Lordship. Your Lordship, the matter pertains to the premature release of prisoners, life convicts.
22. List on.
24.
Obliged, Your Lordship.
This was of.
Pardon me, Lordship, may I mention one matter, my lord? It is humble request, my lord. My lord, I have filed one PIL, WP 6446 on the service matter, and the subjected employee is due to retire on 31st of March, my lord. If it may be kindly listed tomorrow, my lord.
Sorry. No mention time in this.
My lord?
Court officer.